So Republicans are now in control of the House of Representatives with a very thin majority of what NBC News projects will be just 3 or 4 seats, basically. How Republicans achieved this majority in what was otherwise a really bad election year for the party was due in no small part to the gerrymandering that was done in states that Republicans controlled the process in. So take, for example, Alabama. It's a state in which about 27% of the population is black. Ahead of this election, Republicans drew this congressional map you see on your screen for the state. It puts much of the black population into just that one district you see, the one blue district. So you get one seat. That might look big there geographically, but it's one of 7 districts. So 1 out of 7, that's 14%. That's half the percentage-wise of what the black population is in the state. Civil rights groups sued them over this, and a federal panel of judges ruled that the map violates the Voting Rights Act. They ordered Alabama to redraw the map and add another majority black district. But Republicans took the case to their friends on the Trump Supreme Court, and the conservative majority there said, no, the map that gives white voters disproportionate power is fine. Go on. Basically, the exact same thing happened next door in Louisiana. Louisiana is one of the blackest states in the country. A third of Louisiana citizens are black, 33%. And once again, Republicans drew a map with 1 majority black district out of 6, right? And a federal judge ruled the map was illegal for the exact same reason. The federal judge ordered a second majority black district drawn. And the Trump Supreme Court said, no, map is fine. So that's 2 states, 2 seats, right? In Florida, it was even more egregious. In Florida, Republican Governor Ron DeSantis forced the Republican state legislature to actually take away the mostly black district you see on the left. That was the original plan, okay? And break it up into 4 red districts you can see on the new map on the right. This time, it was Florida's own state Supreme Court, dominated by Republicans, which upheld the biased map. That's 3 seats right there. There's a bunch of other examples of Republican gerrymanders either approved by the courts or pursued in defiance of the courts. In Ohio, they basically just told this local state Supreme Court to take a long walk off a short pier. But these 3 alone, that's 3 seats. Alabama, Louisiana, and Florida eliminated 3 House seats, which likely would have gone to the Democrats. Catherine Sadasivan is the redistricting counsel for the NAACP Legal Defense Fund. She worked on both the Alabama and Louisiana redistricting cases I just mentioned, and she joins me now. It's great to have you. Catherine, can you just sort of lay out the case of what current U.S. voting rights law, the Voting Rights Act, 14th Amendment, says about the questions that were issued in the 2 really clear cases in Alabama and Louisiana?
Sure, Chris, thanks. So the Voting Rights Act of 1965, as even Chief Justice Roberts recognized in his dissent in our Alabama case, prevents state legislatures from packing and cracking black voters, in particular, in a way to dilute their voting power. That's also prohibited by the 14th Amendment. The Voting Rights Act, in particular, prevents any kind of discriminatory map that has the effect of denying black voters or any voters of color a fair opportunity to elect candidates of their choice. And in places like Alabama and Louisiana, where we both brought cases, there is a significant history of racial discrimination in voting, but across all sectors of life. So in health, in public education, in healthcare access, and kind of the daily, things that we consider good representation to usually take account of, the lack of political representation affects black voters in particular. And so the Voting Rights Act, as it stood or as it stands today, would have prevented the legislatures in Alabama and Louisiana, and indeed in Florida, from enacting maps that deny black voters a fair opportunity to elect their candidates of choice, and would have required, as federal courts in the district in Alabama and including the Fifth Circuit in Louisiana found, would have required those legislatures or through the court to have enacted a map that provided black voters with an additional opportunity to elect a candidate of choice, meaning that 2 districts would have allowed black voters to elect candidates of choice, right, and all of the commensurate representation that comes with that.
So, I mean, the basic math here, right, is that, like, for years, right, before the Voting Rights Act, you know, it doesn't matter how black your state is, right? If you control the districts, you could just make sure that there's no black majorities in any districts. You have an all-white state legislature, you got an all-white congressional district, whether you're Mississippi, Louisiana, like, that's it, right? Voting Rights Act comes along and says, can't do that anymore. And so then the question is, well, what's the standard here? And if you look at a place like Alabama, it's like, look, the math works out that there should probably be 2 black representatives in this congressional delegation. The Republicans say you get 1. And then there's a trial where a federal judge says, no, you have to do this. You have to draw a second majority black district in Alabama. And then why does that not happen? I still don't understand.
So, I mean, it's in part thanks to the Supreme Court's weaponization of its shadow docket, whereby it, without kind of full briefing and merit, grants the state a stay of the district court's decision. In this case, it was, you know, in Alabama, it was a weaponization of a case that meant that voters and, you know, election administrators are confused by changes too close to an election. And so, right. You know, that somehow justifies discriminatory maps which deny voters within the state an opportunity to elect a candidate, and requires, in fact, that a discriminatory map effectively must go into effect for at least one election before it can be remedied. In Louisiana, I should note, though, the Supreme Court didn't give any justification whatsoever. It was not too close to a candidate qualifying deadline or indeed any election deadline. The Supreme Court just decided that it seemed poised possibly to change the applicable standard for Section 2 Voting Rights Act cases, and that it would hold the case and Louisiana voters in limbo until it rendered a decision in the Alabama case.
So the Alabama case has now been argued, and so we'll get a decision from the court. It likely is not going to be good, but there is an outside chance that this can be remedied in the future, though there's also a chance the court basically keeps taking the sledgehammer to the pillars of the Voting Rights Act, which seems more likely. Catherine Sadasavan, thank you so much. Really appreciate it.
Thank you, Chris.